Sure. I'm Steve Shapiro. I'm the National Legal Director of the ACLU. Well, we don't choose to do one versus the other. We do both. And the amicus practice, we file amicus briefs in lower courts on occasion, and certainly our state affiliates may have an amicus practice in their state Supreme Courts, for example. But the National Office of the ACLU, the bulk of our amicus practice is focused on the Supreme Court. In any given year, the number of direct cases we have obviously goes up or down. Last term, the 2012 Supreme Court term, we had 6 cases in which we were direct counsel or co-counsel. I mean, that was for us, even for us, a very busy year. And they were big cases and important cases. This term, the 2013 term, we have 3 cases in the Supreme Court. We will, in addition to whatever the direct docket is, generally file probably a dozen or so amicus briefs in any given year. So over the past decade, I would say we've averaged between 15 and 20 filings a year in the Supreme Court. And if the Supreme Court is hearing 80 cases a year, it means we're filing in something between 20 and 25% of the Supreme Court's cases. And when we make a decision about whether or not to file an amicus brief in the Supreme Court, there really are 2 criteria that I use. One is this an issue that is important to us, right? Is an issue that we are concerned about for some reason or another? And there are a lot of issues that fall into that basket, just given the breadth of our work. And then the second question is, do we have something to offer? I really do not believe in filing repetitive briefs in the Supreme Court. We are too much of an institutional repeat player in the Supreme Court. I'd like to think that our briefs get read, and I know that they will stop reading them if we're not saying anything that's of value to them. So there may be cases where we think we care about the issue, but it's well covered and we have nothing to add, and then we won't file, or we'll join with somebody else, right, rather than file a second brief. And it's always hard to know. There's a lot of debate going on, obviously, about the impact of amicus briefs, and that practice has changed very much over the course of my tenure. When I first started doing this in the late 80s, there was not nearly the level of amicus involvement that there now is in the Supreme Court. You never saw 40 briefs. By and large, the law firms didn't have Supreme Court practices the way they now have. There wasn't a specialized Supreme Court bar the way there is now a specialized Supreme Court bar. So it hasn't taken us out of the business, but it makes it by a long shot. But it does make me think more carefully always about what is it that we have to add to the mix. And all I know, and I like to believe this because it supports the decisions and work that we're doing, is when periodically there are academic studies, usually of former clerks, surveys of former clerks about what briefs get read and what briefs have impact. The ACLU is usually up there on the list, and it's very important for me for the organization to maintain that role and to maintain that reputation. And we won't maintain that role unless we maintain the reputation, and that means filing good and useful briefs. All of the above. We write a fair chunk of briefs. Sometimes we file them simply in the name of the ACLU. Sometimes we go out and we'll try to solicit, for example, if it's a brief, in the Hobby Lobby, the contraceptive care brief, where there were an enormous number of briefs being filed. The brief that we wrote was a brief that talked in some ways about the civil rights history of religious refusals, right? To try to help the court to understand that this is not a new phenomenon, and that unfortunately religion has been used as a claim justification for discrimination in many other contexts and involving many other issues over the years. And in most other contexts, we've now rejected it as illegitimate. We don't allow somebody to say, I don't want to serve a black customer because the mingling of the sexes violates my religious beliefs. Why should it be any different here, right? And so we try to give an historical context to the current dispute. And when we did that, we thought that brief would be enhanced if it had a broader constituency of civil rights groups that joined it, and civil rights sort of icons. And so we went out and tried to get those people to join our brief. Other times we write by ourselves, and then sometimes, as I say, we will join other people's briefs. Well, I think you always think about what makes for a successful brief. If what you mean by a successful brief is a brief that might move somebody to vote the way you want them to vote, and often, especially in amicus briefs, you may have the luxury of, because you don't have to address every issue in the case, you may have the ability to focus your opinion on a particular justice or a series of justices who might be in play in any given case. I don't think being cited in Supreme Court opinions that's evidence that your brief was read, but I don't think the fact that you're not cited means that it didn't influence the decision-making process. Amicus briefs are rarely, not and occasionally, but rarely cited in Supreme Court decisions. I think there are two things, or three things, I think that an amicus brief can do. Sometimes, although this is increasingly uncommon, but sometimes there just is not a very good merits brief, and that in effect, if you care about the issue, you're writing something that is essentially a shadow merits brief because the actual merits brief has not done a good job of addressing the principal issues in the case. That used to happen more often than it does now, but still occasionally happens. Or much more common is you have a situation in which you have a very, very competent merits brief, but everybody's dealing with a 15,000 word limit on your merits brief, and there may be issues that have been identified that the principal merits brief just doesn't have enough space to address, in which case an amicus brief can fill that hole by devoting more space to something that the merits brief has less space to discuss. And then the third thing, actually maybe there are four things. The third thing that you can do is just empirical. You can present the court with empirical evidence and academic studies and various other things that can help to educate the court as it thinks about the issues. And then the final thing, and this doesn't tend to be something that the ACLU does, but I think it matters to the Supreme Court, is you can submit an amicus brief that is very powerful because of the names on the cover, almost without regard to what is between the covers. And so when the Supreme Court decided the first Michigan affirmative action cases, Gratz and Grutter, in 2003, it was clear that briefs that were submitted on behalf of Fortune 500 companies, military leaders, had a tremendous impact on the court. And I think that impact would have been almost as great if the court never opened it up and just looked at the names on the covers.